A disappointed grandfather who was hurt that his grandchildren didn't visit him more often was entitled to leave them just £50 each of his £500,000 fortune. That is the ruling from a High Court judge after some of his grandchildren tried to stake a claim for 1/3 of his money. Joining me now to discuss this, family law barrister Paula Rhone-Adrien. So nice to see you.
Good afternoon, Vanessa.
I think people might have thought, well, absolutely, it's your money, it's your will.
Absolutely.
You know, if you want to leave one child, you know, one wooden spoon and an old colander, and you want to leave the other child a beautiful house in the south of France, it's your choice because it's your money. But then there's always the possibility, isn't there, that the family might fight afterwards.
Absolutely, and they do.
Right.
Let me tell you, we're very busy, Vanessa. But you're right. If I want to send a message to you from the grave, why can't I? And if that message is, quite frankly, a surly one, and I'm going to get you back, again, why shouldn't I? The thing about this case was that the grandchildren said, I don't believe that this was my grandfather's real message. I think that my aunt and uncle, his two surviving children, I think they unduly influenced my grandfather because he would have wanted me to be happy and he would have wanted me to have all this lovely money. And so that's why I'm going to contest the will.
Oh, I see. And the judge wasn't having it.
Judge was not having it. Now, let's just set the scene a minute here, Vanessa, because this isn't some kind of straightforward, I'm not happy with the will, so I'm just going to go along to a judge and say, change it, judge.
Right.
It's an incredibly long process. It's an incredibly costly process, both emotionally and financially. And we're talking about years here. So grandfather sadly passed away in 2020. And we don't get a judgment until 2024.
No.
So this is the kind of time that we're talking about.
So you're saying this to put people off. If they're thinking of doing this at home, don't just think you just kind of waltz up to court and say, oi, where's my share of the winnings? And the judge says, all right or not all right. It's not as easy as that.
It's not as easy as that. To contest a will, you have 6 months from when probate has been read. And we know that the difficulties that are happening at the moment in terms of getting probate, and then on top of that, you have difficulties in terms of just the court system managing with the backlog still from the pandemic.
Just explain what probate is, because everybody knows you've got to get it, but I don't know whether people really understand what it actually is.
So it's formal. Essentially, it's formal recognition of the will. It's the courts, it's the administration checking that everything is in place and is where it should be, essentially. And what happens is you'll get probate, you'll get the documents, and everyone will say yes, it's fine. Go ahead and now administer the will. The executors should then set out, well, the testator says that you should have £5 and I should have £10. And that's when you eventually get your £5 and I eventually get my £10. But as I said, that is taking a long time at the moment for that to happen. You have 6 months from that date in which you can say, actually, I'm not happy with my £5. I want to contest the will. And you have to be able to persuade a judge that either at the time when I signed my will, I wasn't of sound mind, or that I was unduly influenced, or that I didn't understand what I was signing my name to, or there may have been some other administrative thing that meant that the will wasn't effective. And so what happened is we'll bring witnesses along to support our case, to say that actually auntie and uncle were wicked, or auntie and uncle were mean and kept poor grandfather locked away, and it meant that I couldn't go and visit him. In this case, the judge wasn't having any of it, didn't accept any of the witnesses that came along to support the granddaughters. Now, just imagine this for a moment, Vanessa. We've got family fighting against family. We've got witnesses coming in saying that these family members were horrid and these family members were horrid. Must have been just absolutely terrible. And, you know, sadly, now we see another scenario where a family has broken down and is unlikely to be able to repair itself because there's cost implications, Vanessa. If you bring a case, generally speaking, and you lose that case, you will have to pay the cost of not only your own legal team, but potentially of the other legal team as well.
Wow. So the grounds of that's not very nice, what a horrible person, trying to, you know, wreak revenge or do damage or be divisive or, you know, set one child up and not the other in a will. that's not good enough. You can't just say, look, this isn't fair. There are 4 of us. We should each get a quarter. You can't say that. If you were thinking of saying that, will it all be thrown out before you even get there? Or might you waste all your money going there and just being told you just can't say that?
So, yes, those 3 reasons for you to say to persuade a judge that the will shouldn't be valid is, as I said, that the person at the time was of an unsound mind, that they didn't understand what they were signing, or that they were unduly influenced by a family member or someone else. And if you cannot persuade a judge of one of those 3 things, the case will be thrown out. But often what happens is, because it takes so long for cases to come in front of a judge, you try to negotiate, you try to mediate. I have no doubt that they would have attempted that, but for whatever reason, that mediation and negotiation broke down. And I have no doubt that my brethren, barrister, whoever was representing the grandchildren, would have warned them of litigation risk.
What if the terms of the will are not just unpleasant, but maybe positively immoral? Like, for example, and I have heard of this actually happening, so I'm not just making this up, somebody says, you know, I will leave money to my grandchildren, this amount, this amount, this amount, conditional on the fact that they do not marry someone of a certain race.
Yes.
Or that they do marry someone of a certain race. And if they don't, they can't have the money.
Yes.
Now, that people would say is racist, it's divisive, it's unacceptable, you can't do that, it's controlling, whatever. But can you do that?
Well, what happens in that kind of case is, so no doubt in that kind of scenario, the grandchild would want to contest the will and say that that's incredibly unreasonable, and that shouldn't be something that a court should uphold. And what a judge will do, a judge will ask him or herself, is that a clause that a reasonable testator would make provision for in his or her will? And if the response is unlikely, then that clause would not stand and shouldn't stand.
So what does that mean, a reasonable testator? So somebody whose opinion you agree with?
Well, one would like to think that a reasonable testator wouldn't be racist, wouldn't be sexist, wouldn't want to discriminate, for example, on the grounds.
For example, OK, not racist, let's do a different one. Somebody makes a will and says, I leave this money to my grandchildren, but only if they're born within wedlock. If their parents are not married and they haven't had a proper marriage ceremony, then those grandchildren, whether they're biologically linked to me or not, are excluded from my will. Are they allowed to say that, for example?
That's a really interesting one, and I think that that would challenge a judge. And I think the type of questions that the court would want answered, for example, is, was there some solid reason that the testator left that provision in the will? So, for example, was it a reason based on their religious faith?
Right, what if it was?
And it was a strict religious faith
what
that
if they
had
believe
followed
in holy matrimony and they don't like the idea of
and that
the
they
opposite?
they had lived their life according to that very strict scripture.
Right.
I can imagine a scenario where a judge would be tested by that question, absolutely.
And say, yes, you
and
can.
may say, yes, you can.
May say, yes, that's what that person wanted.
Absolutely.
And that's it.
Yeah, but in that kind of scenario, as we often get in the law, where you have that grey area, you negotiate, you mediate, because you have that litigation risk. You are concerned that the risk is high enough for you to advise your client, I'm not sure what a judge would do. I don't know. I can't be certain. And so on that basis, we should think about, well, what is it that we would walk away with, we'd be prepared to walk away with?
Thank you so much. Absolutely fascinating. Absolutely. And we should say one thing while we're here. I hope you will be healthy and happy forever, but make a will, right?
Absolutely.
Make a will.
Absolutely.
Even if you think you've got nothing, you're not rich,
making
for
a will
God's
as
sake,
well.
make a will.
I know they want you to do it, DIY wills, don't. Just spend, an hour with a solicitor or a barrister.
But make a will, even if you think you don't have anything.
Absolutely.
Always worth doing. OK, thank you.